Hey, welcome to The Explainer. So today, we're not just going to talk about the law in theory. No, we're diving deep into the anatomy of a real, high-stakes civil rights lawsuit by digging into the explosive document that started the whole thing.
Okay, let's just jump right in with the opening lines from an actual federal civil rights complaint. And yeah, you heard that right. These aren't just dry legal words. Think of this as the first shot fired in a legal war, designed to make the court sit up and pay attention right from page 1.
And no, this isn't some Hollywood script. This is a real legal document that's telling a story, a really serious one. It's about alleged corruption at the highest levels of a local court. And the craziest part, the claim is that it's all captured in the court's own official records.
So the complaint really weaves this incredible narrative that involves three key players. You've got a judge, a prosecutor, and a defense attorney. And it's accusing them of all conspiring against two people. These aren't just, minor mistakes. We're talking about allegations that strike at the very core of our justice system.
And this is what the plaintiffs are calling their smoking gun. They claim this court transcript, which was recorded just hours before the sentencing, is basically undeniable proof. Proof that both the judge and the prosecutor knew that the 12-year sentence they were about to hand down was a full 7 years longer than the law actually allowed.
Okay, so you've got this wild story, right? Full of explosive claims and transcript quotes. But how do you actually take all of that and turn it into a formal lawsuit that a court will take seriously?
Well, it all kicks off with something called a cause of action. Now, you can think of this as the legal hook for your whole case. It's not enough to just say you were wronged. You have to show you were wronged in a specific way that the law actually recognizes and has a solution for.
And that cause of action, well, it gets laid out in this official document called a complaint. This is it. This is the starting pistol for the entire lawsuit. It's the document we've been quoting from, and it's where the person suing, the plaintiff, tells their side of the story to the court. And here we go. You can see the actual players in this real-life legal drama. You have the plaintiffs, the ones doing the suing, and the defendants, the people they're accusing. Seeing the names really makes these abstract legal ideas feel, well, real. All right, let's talk about how you build one of these things, because a complaint can't just throw out wild accusations and hope something sticks. No, it has to build its case logically, piece by piece, brick by brick, if it wants to have any shot at all. Yeah, it's kind of like baking a cake. To win any cause of action, you have to prove every single ingredient, what the law calls elements of your claim. If you forget the flour, you don't get a cake. In court, if you miss proving even one of these elements, your entire case just falls apart. You lose. So for this specific claim we're looking at, First Amendment retaliation against the judge, the plaintiff, Rusty Miller, has to nail these 3 specific points. It's like a checklist, and he has to prove every single one.
First up, step 1. He's got to show he was doing something the Constitution actually protects. In this case, the complaint argues that giving a court evidence that might prove someone's innocence and documenting misconduct, that's pretty much core First Amendment stuff.
Okay, step 2. He has to prove the judge actually did something bad to him in response. And the complaint lists some really serious stuff here. Warrantless searches, publicly revealing private info, even making up criminal accusations, all from the judge's bench.
And this is the clincher, right? The third element. You have to connect the dots between the first two. And here the complaint makes a bombshell claim that the judge himself admitted why he did it, right on the record, saying he went after Miller for, quote, filing stuff in my court file. That's the link. That's what makes it retaliation.
Okay, but what about the people being sued? They don't just have to sit there and take it, right? Of course not. The law gives defendants a few standard ways to fight back against a complaint.
And they basically boil down to these 3 strategies. First, you've got the simple denial. Nope, didn't do it. Then you've got what's called an affirmative defense, which is more like, okay, maybe I did it, but there's this other legal reason you still can't win. And then there's the counterclaim, which totally flips the script. Actually, hold on, you did something wrong to me. So once the complaint is out there and the defense has responded, the battle lines are officially drawn. Now the case moves into a whole new phase, one that's all about digging up evidence and trying to prove your side of the story.
But this brings up a really tough question. In a lot of these cases, the biggest injuries aren't ones you can see on an X-ray. I mean, how do you prove something like emotional distress? How do you put a dollar amount on a ruined reputation?
And that's where expert witnesses come in. They're a huge part of this next phase called discovery, where both sides are digging for evidence. These aren't just any witnesses. They're specialists, like a forensic psychiatrist who can come in and provide an objective, professional opinion on these complicated issues and help a jury understand the real-world harm that was done.
So all this detail in the complaint we're looking at, there's a reason for it. And it brings us to this massive, really recent shift in the law that totally changed the rules for how lawsuits even get started.
You see, for decades, it was pretty easy to start a lawsuit. All you needed was a short and plain statement. They called it notice pleading. The whole idea was just to get your foot in the door and sort out the details later. But then, two huge Supreme Court cases, known as Twombly and Iqbal, came along and just threw that whole system out the window. They brought in this much tougher plausibility standard.
So what does that actually mean? It means that now, right from the get-go, a plaintiff has to lay out a super detailed, fact-heavy story in their complaint. The court's reasoning was to filter out weak or bogus lawsuits early on. You can't just allege something is possible anymore, you have to show it's plausible just to get past the starting line.
And look, this wasn't just some academic debate. It had real-world consequences. The data shows that after this change, the number of constitutional civil rights cases getting thrown out of court right at the beginning jumped from about 50% to 60%. So it's definitely made it harder for these kinds of cases to even get off the ground. So this really leaves us with this giant debate about what it means to have access to justice. Is this new, tougher standard a good thing? A necessary shield that protects people and the courts from frivolous lawsuits? Or has it become a new kind of wall, blocking real victims with legitimate cases from ever even getting a chance to be heard? That's really the big question hanging over our court system today.